I warned you that I would expose you if you made moves in representing Brian Kolberger that indicated that you was working with the district attorney to convict Brian Kolberger. Today is October the 5th, 2023, and it's time to expose you as well as Mr. Bill Thompson. The first mistake that you made, that no legal analysis, nor your colleagues are calling out because they can't, because they are part of this problem as well. You trick, you deceive, you dupe Brian Kolberger into waiving his right to a speedy preliminary hearing. This was a strategic move that you placed on him to help you and Mr. Bill Thompson, and I'm going to prove it. What advantage did waiving the speedy preliminary hearing give you and Mr. Kolberger? None. It gave you none. Now, if you're going to argue that, or if any of your colleagues, any legal analysis is foolish enough to come on social media and say, hey, she needed discovery to defend him at a preliminary hearing. If you or anybody take that position, you're incompetent. And I'm going to prove it. Any trial attorney, any student of the law, any pro se litigant that seriously studies the law knows that discovery can take months. Discovery can come at a standstill. Discovery can come at a standstill to where you have to file multiple motions to compel. So, when you waived his right to a speedy preliminary hearing, what was you really doing? I'm going to tell you what you was doing. You were working in conjunction with the district attorney to achieve three things. The first thing was not to have a preliminary hearing. See, the waiver of the speed of preliminary hearing was already predetermined to foreclose a later preliminary hearing because the indictment was being prepared. Bill Thompson needed time to prepare the indictment. And Ann Taylor knew this. Now, this is why they chose her to represent him. They needed a flunky. They needed somebody that's going to play ball. Stay with me, I'm going to prove this here. You waived a speedy preliminary hearing, and you made the public think that, oh, we're going to schedule later down the line. But what the public don't understand is you have a right to a speedy preliminary hearing. There's a difference. See, if you waive that, there's a possibility that you won't get a preliminary hearing because the district attorney now have a lot of time to convene a grand jury. You see where this is going? Now, your first objective was not to have a preliminary hearing at all. The whole charade about scheduling it down the line, there was a game. This is why after you waived the preliminary hearing, you asked for a scheduled conference. You didn't immediately schedule a preliminary hearing later down the line. All these delays you're doing. But guess what all these delays indicate? And what the Court of Appeals, the Idaho Supreme Court will tell you. You are in effect waiving a speedy trial. Okay. This is why you end up waiving a speedy trial. It's all a game. You knew October the 2nd, y'all wouldn't be ready for trial. Not because you couldn't get ready. It's because This is a pre-planned event. This is a payout for you. Everything that you have done so far indicates that you are ineffective as counsel and that you are in a conspiracy to convict Brian Kolberger. See, a preliminary hearing would have been public. This is not what Bill Thompson wanted. It's not what you wanted. You know why? Because now at the preliminary hearing, we would have heard what they got, what the witnesses allegedly said to the police, how the police conducted the investigation, how they gathered any evidence at the crime. And I'm going to prove this to you. See, everything you trying to get from Bill Thompson through discovery, you would have found out at the speedy preliminary hearing. But see, a lot of people don't know this. A lot of these lawyers are keeping their mouths shut because they're incompetent as well. They probably don't know. I find it hard to believe that a lot of these attorneys don't know this. But the thing about it is, attorneys will never expose other attorneys that's incompetent. So I have to do it. Now, check this out. Right now, Ann Taylor is stressing the indictment should be dismissed. She can get a preliminary hearing. It ain't gonna happen. Once that indictment hand down, it's over with. You don't have a right. You don't get a do-over. Now, why y'all think she's pushing for this preliminary hearing all of a sudden? I'm gonna tell you why. Because the Supreme Court of Idaho is gonna look back at her conduct and they're gonna say you was ineffective at this particular stage of the proceeding. See, everything you trying to get now, and they putting up roadblocks, you could have set up to get then and later. And so let's get to this video and I'm going to show you. Then I'm going to come back and put context in. So I'm going to go right over here to this computer. We're going to crank this computer back up and we're going to get right to it. Did my computer shut down after a while? But don't worry about that there. There it is. So we're going to get back into this here. So I'm going to get on this computer to show you exactly what Ann Taylor would have already achieved had she not waived the speedy preliminary hearing. Let's get into it. All right. I want to make sure you can see it. So I'm going to move my camera over here. Now, I want to be clear on one thing. Idaho Criminal Rule 5.1. This is what it say. A preliminary hearing. Unless indicted by a grand jury, a defendant charged in a complaint with any felony is entitled to a preliminary hearing. If the defendant waives the preliminary hearing, the magistrate, we're going to stop right there. Now, if you notice, you have a right to a preliminary hearing as long as an indictment is not handed down. So let's move on, because what I want to show you comes next. This is what Ann Taylor didn't want y'all to see, but I saw it. Probable cause finding. If the magistrate finds that the public offense has been committed and that there is probable or sufficient cause to believe that the defendant committed the offense, the magistrate must immediately require the defendant to answer in a district court. The finding of probable cause must be based on substantial evidence of every material element of the offense charge. Hearsay in the form of testimony or affidavits, including written certification or declarations under penalty of perjury, may be admitted to show the following. Pay close attention. This is what I want you to focus on, number 4. Reports of scientific examination of evidence by the state or federal agency or officials or by the state certified laboratories. Let's stop right there. Remember the knife sheet that they did a workup on, the SRT or whatever you want to call it. They did the workup, then find nothing. Then they sent it to the lab in Texas. They would have to make known that lab. Do you see now that Everything, let me keep going. She could have got the laboratory where they sent it. She could have found out. Y'all still waiting on DNA. Where did you find it? Etc. Etc. Okay. She could have cross-examined the police. At this time, at this point, Ann Taylor was working with Bill Thompson not to have the federal agencies who helped work up that information come in and testify or submit affidavits. This was the reason why they waived the speedy preliminary hearing. Ann Taylor is not defending Brian Kolberger. Let me finish. Reports of scientific examination of evidence by the state or federal agents or officials or by the state certified laboratories. Remember, state certified laboratories. Provided that the magistrate determined that the source of said evidence is to be credible. Nothing in the rule prevents admission of evidence under any recognized exception to the hearsay rule. The defendant is entitled to cross-examine, examine witness produced against the defendant at the hearing and may introduce evidence on the defendant's own behalf. Motions to suppress must be made in a trial court provided by Rule 12. However, if at the preliminary hearing the evidence shows facts which would ultimately require the suppression of the evidence sought to be used against the defendant, the evidence must be excluded and must not be considered by the magistrate in determining probable cause. A record of the proceeding must be made by stenograph means or recording device. Now, let me bring something to your attention. All right. Matter of fact, let me just bring it back to where I was at while I'm talking. All right. Get this back over here. Now, as you can see, if you go back and look at that, Ann Taylor could have got everything that she wanted at the preliminary hearing because this what would have happened. She would have been able to talk to the officer that collected the evidence, got the names, because they would have had to testify. Who did you talk to? What did the two surviving roommates say? And then also, even if Dylan Mortensen or Bethany Funk wasn't there, the substance of what they told the police could have been explored. So, as you can see, there is no reason for Ann Taylor to have waived the preliminary hearing under the rules that she needs to conduct discovery, because this sets you up for discovery, the preliminary hearing, man. So, as you can see now, that hearing would have been public. The whole object of Ann Taylor and Bill Thompson charade is to keep the public ignorant of the facts of this case, because one of the big goals I always said, they don't want you to see the photos. This is what they're already working on. They don't want the public to see the photos of the crime scene. They don't even want the jury to see it. There will not be a trial in this case, people. This is why everything is quiet. The death penalty is coming off the table. All this is a charade. Go back and look at my videos. I told you, this is a charade. It will end in a plea bargain. Ain't finna be no trial. Because, think people, if it's going to actually be a jury trial, why is all the information trying to be concealed, motion redacted, filing? They don't want you to know what's going on. That's a sign that a plea bargain is going down. And as you can see, if you go look at the preliminary rules dealing with that, she could have got everything, the agency who worked this out, what an affidavit. As you can see, the preliminary hearing was waived to conceal that. So this whole thing she's doing now, it's a ruse, man. Brian Kolberger will be found guilty. Welcome back to Speak Van Holen. Y'all have a nice morning.